my lord. My name is Lukwago Erias. My name is Lukwago Erias.
Scheduling and directions.
For scheduling and directions to be given by this honorable court. Yes, my lord. But we have concerns to be raised, my lord. Yes, my lord.
Yes.
My lord. Again, as per the record.
Are you saying, Councillor Lukwago, that I don't, court doesn't go ahead to give directions and scheduling? Is that what you're saying?
Yes, what I'm asking for, my lord.
Yes. I just want to establish that the matter was coming for this court to give directions for this bail application.
Yes, my lord, the matter is coming up for directions.
Yes, but however, you have some
concerns to raise, my lord. And an application to make, my lord.
About what? Just the key. About what?
Recuse, my lord.
There is a ruling for recusing this application.
Yes, there are issues that are not canvassed in that earlier ruling.
Come again?
There are issues that were not canvassed in that earlier ruling, and I don't intend to repeat those issues that you addressed in that ruling, my lord.
Under which law now, after the recusal ruling, under which law can you move in court again?
My lord, is the Constitution. The Constitution.
Let me capture this. So the concern is about what again?
The concerns relate, my lord, to, if I may highlight the issues.
What?
Recusal, my lord. It's about recusal.
That's right.
And it is, my lord, a new application, a fresh application for recusal, which is allowed under the law, my lord.
Under which law?
The Constitution, recusal of judicial officers, practice directions, 2019.
Which rule are you invoking?
Rule 6. I have, my lord, 2 rules, or regulations.
Read rule 6.
Sub-rule 3B.
Rule 6.
Sub-rule 3B.
What is the time of that?
My lord,
I wrote the apologies, which I did from Luka. Chief Secretary. I came together with my colleague, Joseph Chomtengo. Joseph Chomtengo. Also Chief Secretary. For the respondent. Joseph Chomtengo. For the respondent. This council, you said you are now moving important about 6-3.
3B, I will come to the 3-1. I mean 6, 3B, sub-rule.
Yes. What does it say?
Where it comes to the knowledge of the judicial officer during the course of the hearing, that for any reasonable cause matter, the judicial officer shall state or record the reasons for recusal, notify the parties, and return the file for reallocation to another judicial officer.
Councillor Lukwago, I handled that in my way.
No, my lord,
this
rule is very wide. Provides for any reasonable cause. And my lord,
read the 8. Read the rule 8.
Rule 8.
4.
4. Where judicial officer declines to recuse himself or herself, the reasons for declining shall be noted on the record, and the matter shall proceed for hearing. My Lord, the issue here.
No, I just I'm trying to highlight harmonize with you. This I have put at 6. We have grade 6.
Yes.
3B.
3B.
And I am saying we considered that in my ruling, and I'm telling you to address yourself on 8.4. I gave these reasons.
My Lord, I will also draw your attention to that rule 8 you are talking about, my Lord, sub-rule 1.
Really?
A party who seeks the recusal of a judicial officer under paragraph 7 shall by letter copy to all the parties and the registrar of the court or orally in open court in the presence of the parties request the judicial officer to recuse himself or herself.
Fine.
Yes.
Say this one will invoke it.
My Lord, there is no limit
To go to 8. 5. I have finished 8.4. Let us address as of now 8.5.
8.5, where a party is dissatisfied with the decision of a judicial officer not to recuse himself or herself, the party shall state the reasons and the hearing shall continue.
What is your take on that?
My Lord, we are going to state the reasons why we are dissatisfied with you.
Go tonight.
Arising out of the failure to grant an application for recusal shall be made after the matter has been determined.
Yes.
My Lord, here we are not raising an appeal. We are raising a fresh application for recusal, which is not allowed, prohibited under the law.
And I'm asking you, under which law are we moving?
This is what I'm saying, my Lord. Rule 6 allows as many applications as possible.
Where are you getting that?
That's what it says. If you have, my Lord, if you looked at sub-rule 3B, it is wide. It talks about any reasonable ground, my Lord.
Which I am saying.
That is sub-rule 3 of rule 6. Sub-rule 3B of rule 6. It gives us wide latitude, my Lord.
So let me, you are invoking rule 6.
Rule 6,
3.
3B.
Relating with what?
Recusal, and we have reasons which are totally different from the reasons that were canvassed in the earlier applications, which are captured in your ruling. We have reasons and grounds, my Lord. We have grounds for recusal. Yes. Which are totally different from the earlier grounds that were canvassed in that application that we disposed of. Which are totally different from the reasons that were canvassed in the earlier application that you disposed of. And this is a fresh application on fresh instructions. Yes.
These instructions?
Yes, madam.
I want to say before we proceed whether to cross around. Just I'm saying you can see, so you want to respond to what you have said. But you see that.
If I may finish the submissions, my Lord, in that particular argument.
The issue here, you are saying you have an application for recusal to raise which is different from the court.
Yes, my Lord.
Yeah, so you see it and just want to just to want to listen to the response. before I respond. My Lord, the submission of my senior colleague. The application, my Lord, received was really hard and determined. Doesn't matter whether it has a different reason. But in fact, the respondent has been on record arguing that this is an abuse of the process. We don't have the same applications over the same matter, same parties seeking the same remedy. That's it. Even if it were not an abuse of the process, my Lord. My senior colleague is relying on Rule 6, Sub-Rule 3B. And my Lord, from the reading of the rule, senior counsel has no locus to make an application under that. This rule only applies to a judicial officer. Allow me, my Lord, to read perfectly. Where it comes to the knowledge, where it comes to the knowledge of the judicial officer, Rule 6, 3B. The application is being brought under 63B.
Yes. Which one are you?
I'm reading B. 3B.
Yes.
Where it comes to the knowledge of the judicial officer, during the course of the hearing, that for any reason, that for any reasonable cause, he or she cannot continue handling the matter, the judicial officer shall state on record the reasons for recusal, not facts, premise the application, give them space. Application or matters before court are premised on the law. There must be a provision of the law that allows one of the parties institute any application before court. And therefore, my senior colleague should have looked or should have premised his application on another rule, not Rule 6 3B. In the circumstances, my Lord, it is our prayer that you be pleased to dismiss the application and the main application proceeds.
Yes, Council.
So, otherwise it is wrong, my lord, for senior counsel to impose this rule on you, my lord. It is on your own initiative, evolution as a judicial officer. We so pray.
My Lord, thou failed to make head and tail out of this submission.
You respond if you
Yes, I'm responding, my Lord. And indeed, this is what I'm doing, my Lord. Because the reading of this rule is clear.
But the 6
63b, the reading is very clear. For clarity purposes, let me read it again.
No, I have it. Yes, I have it.
You know, for myself now, to substantiate the argument I'm going to make. Where it comes to the knowledge of the judicial officer during the course of the hearing, that for any reasonable cause he or she cannot continue handling the matter. How does it come to the knowledge of the judicial officer in the course of the hearing if you do not permit a party to bring those matters to your attention? I am here to bring those matters to your attention, so that you make a decision that you cannot proceed with the matter. So how else would you know that there are reasons that will forbid you from proceeding with the hearing of the matter unless I'm given an opportunity to present the same to you? That's why I'm not making head and tail out of it. That his submission is illogical. It is illogical. Secondly, my Lord, I need to reiterate the Erias submissions I made. That this rule is very wide. For any reasonable cause, it is yours to take a decision, one more or the other. So you cannot in any way be hard to assert that I am imposing our position on the judicial officer. No. We want to present our case before court. And then the decision is made, one or the other. So it will be a travesty, my Lord, as I conclude, for this honorable court to bar us from presenting whatever case we have on behalf of the applicants for court to hear the merits of the same. We reiterate our prayer, my Lord, that you permit us to bring these matters to your attention and you take your own decision accordingly. We do so.
that I have perused this file, this application, and noted that application for refusal was made, it was considered by this honorable court, and the ruling was delivered on 19th August, when both declined to refuse, and the reasons are given that today, when the matter was coming for scheduling and directions, this council Lukwago raised some concerns and said that he wanted to make another application for refusal. Under Rule 6(3)(d), now, I will just address myself to Rule 8, Clause 4 of the Constitution of the Refusal of Judicial Officers Practice Direction 2019. I report publicly that when a judicial officer declines to recuse himself or herself, the reasons for declining shall be noted on the report, and the matter shall proceed with hearing. This court indeed gave the reasons for declining to recuse on 19th August. My understanding of Rule 6(b), Rule 6(3)(b), and the same is addressed in Rule 8(5) in the same directions, which states that where a party is dissatisfied with the decision of a judicial officer not to recuse himself or herself, the party shall state the reasons and the hearing shall continue. It is my considered view that Council Lukwago has already told the court that he was not satisfied with the decision of this honorable court. Hence, he wants to raise other reasons for recusal. My view is that if counsel was not satisfied as he submitted, the same has been noted that he was not satisfied with that ruling. And I have put it to the report that he was not satisfied. And it is my view that since this case was coming for scheduling and directions, this application, I hereby direct that this application will proceed with hearing in the presence of the applicants on 9th October.
My Lord, before you take a leave of the matter,
Yes,
my Lord, before you take a leave of the matter,
yes.
I just want to be on record. I have no instruction to proceed with receiving the directions and also participating
No
in the
problem. I
scheduling.
am ordering the registrar to issue production warrant for 9th October.
My instructions were restricted, my Lord, to raising the concerns.
Which I have put, I have
Yes,
said
but
what
as far as directions are concerned,
Yes.
I have no instructions to receive the same.
No problem. I have directed that I will proceed with this application for the 9th
My Lord, the name is the family.
He's factors official. He's factors official.
My Lord, this court is not functional official. This court is not factors official. It's a public holiday. My Lord, yes, ma'am.
Vamos lá, você foi para o fundo, eu não estou ainda aí.